Our presenters today are Joshua Eide. He's a staff attorney with Legal Aid of Arkansas. He's currently a member of the Consumer Protection Team. Prior to joining Legal Aid, he worked as a deputy public defender in Washington County. We also have Mallory Sanders, who leads the Consumer Protection Team at Legal Aid of Arkansas. Before joining Legal Aid, Mallory worked both in private practice and in-house in tort litigation. The Consumer Protection Team successfully represents hundreds of individuals every year in sealing their criminal records. So I'm going to go ahead and hand it over to our presenters. Thank you for being here today.
Thank you, Christy. And Christy and Josh, I'm charging both of you with waving me down if my slides aren't moving or something is going wrong technically on my end. But hi, welcome. Thank you guys so much for joining us. I just want to give a little brief primer on Legal Aid in the beginning, just to kind of see where we are coming from. So Legal Aid of Arkansas and Center of Arkansas Legal Services are the two legal aid organizations in Arkansas. So here at Legal Aid of Arkansas, we handle the top half, that blue area, and we do have 9 offices, including a fair housing office and an office in Arkansas Children's Hospital in Little Rock. So we provide free civil legal assistance for Arkansans that are under 125% of the poverty level. Last year alone, we closed almost 7,000 cases, impacting 19,000 people. Half of those, of course, were children. So when most people hear of legal aid, they think of custody and divorce cases. And we obviously do a fair number of those. Domestic justice work is about 50% of the cases that we handle, but we are divided into 4 substantive work groups. So we also have a housing team, an economic justice team, which handles public benefits, as well as our consumer protection team. So our record sealing practice is housed within the consumer protection team itself. Our goal within consumer protection is to secure and stabilize families. So by helping to secure housing and employment through sealing records, we meet our consumer goals. And also housed within consumer protection is our low-income taxpayer clinic. We have a very robust LITC program here. The LITC represents, educates, advocates, and identifies issues for Arkansans. Last year alone, they were able to recover $738,000. So before we get into the heart of record sealing, I would like to see who's joining us, what kind of audience we are made up of today. So our first poll should pop up. I can't vote as a panelist, apparently. I'm a little offended.
I was trying to. I got to bump those numbers up.
Okay, it looks like it slowed down enough. So it looks like about 19% or 6 people are legal aid or public interest, 56% private practice, 3% court clerks, 3% government, 3% law student, and 16% are not attorneys.
Awesome. Well, welcome. I'm hoping to make this a little interactive as much as possible. So if you do have questions, feel free to drop those. If you have stories or anecdotes to share about cases that you've helped with, we would love to hear about those as well. All right, so first I kind of wanted to talk about language itself. A lot of people refer to this practice as expungement. And as you probably know, we don't have expungements in Arkansas. And so this is the hill that I'm going to die on. I try to make all of the people that I work with use the correct language. I try to empower my clients to use the correct language. We do record sealing because there is a difference. Your record doesn't actually get destroyed or ever go away. So we can seal records and it's sealed from the public view. There are always people that can see these records though, prosecutors, law enforcement, judges, ACIC, and a lot of times employers as well. So right here, the statute noticed is the statute that allows people to say that they have not been convicted of a crime or that the offense did not occur. And so record sealing in Arkansas is what allows them to do that and to get those jobs and that housing that we discussed earlier. So of course, there are benefits to sealing your record, or else we wouldn't be here. It does hide your record. It pulls it off Court Connect. Generally, the public can't see it. You can use that language from the statute and state the offense didn't occur. It does help get jobs. So a lot of times the background check companies successfully clean their records as well, and it doesn't show up, but it may still show up on some background check companies. And Josh will talk about that a little bit later on tips to avoid that. Sometimes employers will find out through another means that you had an arrest or a conviction, and they may think that you have lied to them on your job application. And it will not restore your gun rights, and it does not restore your right to vote. It's much easier to restore your right to vote, but sealing your record itself doesn't take care of that. So before we really dive into it, can you tell me, I know there are a lot of private practice attorneys here, is this part of your practice? Do you seal records actively on behalf of your client?
Well, that's while we're having that poll, there was a comment from Tabitha Lee. Apparently there used to be expungement. I have had both courts and ACIC tell me that records are expunged. So maybe that's why the verbiage is still hanging around.
Absolutely. We're trying to help educate our clients so we're not disappointed whenever their records are not expunged at the end of the day.
Okay, it looks like we've got all the responses in that we're going to get. So about 55% said yes, it's part of their practice, and 33% says no. And evidently I left an untitled option in there that got 12%. Sorry about that.
They're considering it.
Yeah, that's a maybe.
All right, so Josh, you want to take it away?
Yeah, first I want to say thanks everyone for being here. I think there are a few people that are familiar with me, so I probably don't need to say this, but I apologize in advance for any rambling. I think this is an interesting topic. It's really important to me, and I'm happy to answer any questions. Feel free to type in the chat or contact me afterwards. As Mallory mentioned earlier, I'm a staff attorney, or I think it was Christy mentioned earlier. I'm staff attorney here at Legal Aid. I've only been here 2 months, but before this, I was a deputy public defender in Washington County for 4 years. While I was there, I couldn't seal any records. That wasn't part of our representation, but it was definitely part of what I did and how I advise clients. Everyone wants to know, once I completed my sentence, what do I do? How's it going to affect me in the future? So record sealing and the process was something I was very interested in, and it can make a huge impact. I would talk to clients several months after, a year after, or I'd unfortunately see them again, and they would often tell me they have been denied for a job because of this. What do I do? How can I fix this? And so it's a big thing. It seems small to some people, but I think it's an area we can all make a big impact. So that's why it's a focus here at Legal Aid. Today, I'm going to talk about broadly just what I think the best practices are for sealing a record, and then just go over an overview of that process. In a little bit, I'll go over the more specific statutes and what the law is, the black letter law on how to seal records, what the statute authorizes the individual to say, what the remedies are, what the standards and burdens of proof are, all that stuff. And then lastly, and sporadically throughout as well. One moment. Okay. So it sounds like my microphone's breaking up. I'm going to go into Mallory's office and continue. I'm sorry, guys. Be right back. All right, so now I'm Mallory Sanders, probably the less interesting version, so I apologize for the technical difficulties there. As I mentioned, I'm going to be going over the process generally, what I think the best tips are, best practices, and then later we'll go over the specific statutes and some of the new updates. So the first step, in my opinion, is always collecting the documents. And I think this is kind of universal with a lot of lawyer work. Collecting the documents I think are most important are the sentencing order from the offense you're trying to seal, any relevant judgments or any documents confirming that the judgment has been satisfied. But then also an important thing to obtain is from ACIC itself. For those of you who aren't familiar with ACIC, the Arkansas Crime Information Center, whenever you're pulled over, the officer runs a check on you. It's querying that database, and that database is where the records are sent for arrests, convictions, and a lot of other things. So you can actually ask ACIC to tell me what you got. What do you have on me? And they will send you a record of you or your client, what their records show you've been arrested for, what they show you've been convicted of. And that can be helpful to inform you on the next steps you need to take for your clients. We get a lot of clients who don't know what's on their record. I was arrested back in 2005. I don't remember what it was for, but I tried to get an apartment now and they said no. I don't, and they may not remember exactly what the disposition of that case was. So a really easy step to figure all that out, instead of calling different clerks and asking around, is to just request it from ACIC. And they make it pretty easy. There's a link to the form in our PowerPoint, which I believe was sent out to all of you. But if not, you just Google ACIC forms and it should take you right to their page. It's a long list, but right at the top is the authorization for review. The next step is to determine the eligibility of your client and then to determine which petition to use. We'll talk later about what's eligible to be sealed, what is not eligible to be sealed, and there's a lot of information there. That's where the bulk of this work is going to be, is determining what you can do. Next, you will, yes.
We have a few questions if you want to go ahead and take them.
Sure. Yeah. Would you read the questions out to me? I'm not familiar with Mallory's computer.
Yeah. Are there any cases that deal with lying on an application when sealed records come up and employees get fired?
I'm trying to find it now. I'm not familiar of any published cases that deal with lying on an application. It's an interesting question. There are plenty of remedies for if your petition is sealed and then it's disclosed by the background check company. There's a remedy for that. I'm not familiar of any cases that dealt with where the petitioner lied and then the petition was thereafter sealed or granted by the judge. I think most of those are caught pretty easily because the judge or the prosecutors will take a look and try to figure out if the person's eligible to be sealed, they'll object to it, and maybe a hearing will be held or not.
Okay. And then we have, who is entitled to receive notice of your petition? I have heard the sheriff's office is entitled to notice, as well as the judge and the prosecutor.
So you file the petition and you have to serve it on the prosecutor for that jurisdiction. I think there is some confusion about whether or not the arresting agency also has to be served. The statute says is if they're a party to the case. I can't think of a situation in which the police department would be a party to the case. I err on the side of it's best to serve them anyway. I don't want to get rejected for it just because I didn't go hand a copy to the front desk of the sheriff's department. So I don't, in my opinion, it's not necessary, but it can be done. It should be done just to cover all your bases.
Okay, couple more. When the statute at the time of judgment being entered stated it would be expunged under a certain act, why is that still not the case?
So I'm not sure of any statutes that would state the offense would be expunged, except for the record sealing statutes. I'm not sure if you could follow up with me on that. The sentencing order can specify if something's pled pursuant to an Act 346, in which case it would be dismissed and sealed, and I'll definitely get into that. But I can't think of any criminal statutes that within the statute say this will be expunged at a certain point in time. But I'm definitely happy to look into that if you can give me some clarification on what if you have any examples, I'd be happy to look at it.
Okay, and one more, is there a fee to get the authorization for review?
No. It's pretty easy. You just send it. I find fax to be the easiest way, and then they can email it or fax it back to you. Things get lost in the mail. ACIC is a big place, so and we're pretty quick turnaround too if you fax it to them. So I'd suggest fax, and there's no fee to review your own criminal history or have your clients requesting it and then having it sent to you. There's no fee.
Okay, and that's it for now.
Awesome, good questions. Anytime, all these questions are good. So as I mentioned, the next part will be once you've determined if they're eligible to be sealed, what's eligible to be sealed, selecting the correct petition, and then completing that petition and then filing it with the court. Of course, just like any motion or petition, generally you submit the proposed order along with it. Some judges are real picky, and if it's not included with it, they won't even consider it. So definitely include the proposed order when you file the petition. In some cases, there'll be a hearing after that, and I'll definitely get into that. That's probably the most intensive part of this if they occur, but it's pretty rare. In my experience, it doesn't occur all that often. And when it does, there's usually some unique factors going on that make it different. Then the petition's granted or denied. When it's denied, there are some remedies, and then when it's granted, there are some steps to take, which Mallory and I will be talking about in the practice tip section. And after that, hopefully it's made a big impact for your client.
We have a couple more questions if you'd like
Sure.
to take.
Yeah, please.
When a case is held under advisement in district court, do those records need to be sealed after, or is that automatic?
So this is another instance where district courts vary a lot. I've had some district courts where their policy was under advisement means it's never even sent into ACIC. It's never even sent into driver control. It's just kept in their records. I've had some that send it in, but then they automatically file the seal at the end of the advisement period. So it's a little inconsistent, but I always err on the side of file it. If you file it and it's already been sealed, you wasted some time, I guess, but it's better to know. In my opinion, the probably correct way for it to be done is it's not sent to ACIC, and then at the end you have to file a petition to dismiss or seal, depending on how your court handles under advisement, and then at that point it would be sealed.
Okay. And what do we do when ACIC report reflects something different than the sentencing order? For example, ACIC says battery third and sentencing order says aggravated assault.
Not uncommon. Definitely not. And one of our practice tips is another reason to get that ACIC report, because it is often, I wouldn't say inaccurate, but it can be inaccurate. The best thing I found to do is call ACIC, get a copy of what the petition or what the sentencing order should reflect, and then provide it to them. They actually answer the phone really, really well. So you can just call them, and I've on several occasions gotten through to the records dealings team or just the entry person answering the phone and said, look, I've got this client, their report reflects something different than what the sentencing order shows, and they correct it right away. It's pretty quick. So my suggestion in that case, which is not uncommon, is to contact ACIC.
Okay, and that's it for now. Oh, well, no, one more popped up. I'm sorry.
No problem.
Oh, it's a comment. The ACIC reports are wrong 25% of the time.
Yeah, I think that's probably a conservative estimate too. A whole nother CLE could be actually a step-by-step process, and we're looking at these ACIC forms and pulling out the relevant information. But I don't think anyone wants to sit around and listen to me talk for 3 hours on Friday afternoon. So, but yes, they are wrong quite often.
Okay, we have one more come in. Should we confirm with the district court judge what under advisement means in his court? Meaning, will the record sealing occur automatically at the end of the advisement period per the fact the judge does not, or I'm sorry, the judge does send the under advisement to ACIC?
Yes, I think you should confirm with the judge, but maybe with the clerks. I've found, and I've always said, my support staff is going to be smarter than me. I may be a lawyer, but the people who actually handle the paperwork are often know more about it. So I would check with maybe the judge who may point you to the court clerk. So the court clerks, I think, are going to be really knowledgeable about what the judge has them do with those records. So that'd be a good information point as well. But yeah, I would check with the judge to see how they handle it, because it does vary, which is an odd thing, but it does.
Okay, and we'll let you get back to your presentation. I think we got through the questions.
Awesome. So next I was going to talk about the different record sealing statutes that are out there. And there's a few of them. I think the first and most important is the First Offender Act. Everyone calls it Act 346. The next is the Comprehensive Criminal Record Sealing Act of 2013, and that's a mouthful. Some people just call it CCRSA or just the Record Sealing Act. Older, but still kind of relevant, is the Community Punishment Act. People call it Act 531. And then lastly, I think it bears mentioning specialty courts have their own statute. They also have their own sealing forms. So those are relevant as well. So the First Offenders Act, I think this is the most powerful of the record sealing statutes, but it's almost the most limiting as well. You only get one. And it's important to note that the individual must have been sentenced pursuant to this act. If they just go through their case regular, they're sentenced to whatever their sentence is, and then they come to see you a year or two later, and you ask them if it was this 346. No, I've never used it. Well, they can only use it if they were sentenced pursuant to that act. So when you're gathering documents on that case, it's important to note whether or not the sentencing order reflects ACIC, or reflects that Act 346 is involved. Oftentimes there's a separate order as well that goes along with it. And I think ACIC prefers that, but some judges just mark it on the sentencing order, and that's that. Some other facts about 346, they must be sentenced to probation. This is not for anyone sentenced to ADC, Department of Corrections, or anyone sentenced to suspended sentence, or just getting jail, like if they're sentenced to time served. It must be to probation. It could be probation of 1 year or unsupervised probation, but it must be probation, and it must be successfully completed. If they're revoked, if their suspended sentences or their probated sentence is revoked for whatever reason, they lose the ability to seal it pursuant to Act 346 down the road. There are several offenses that aren't eligible. There are a lot of offenses that are eligible, and ultimately this can't be done if someone goes to trial and is found guilty. This must be a guilty plea or a nolo contendere plea. So what's the big deal? What does it do? The reason I think it's the most powerful is because there's never actually a finding of guilt. The statute's very explicit, and I encourage you all to go review it. It's right there. It's 1693-303. It specifically says that the court does not enter a finding, does not make a finding of guilt, and that proceedings are stayed pending the probation. And I think that'll come into play later. And importantly, this is one of the 2 ways to restore gun rights. It is not done during the pendency of the probation. During probation, they're still a felon. They cannot possess their own guns. But after they successfully complete their sentence and have their charges dismissed pursuant to Act 346, their gun rights are restored. Next is the Comprehensive Criminal Record Sealing Act. And this is going to be the bulk of your practice if you decide to start sealing records, or you are sealing records. It's found at 1690, 1401, and extends to like 1417. It lists eligible offenses, ineligible offenses, It goes through the process for appealing and having hearings. It's kind of your one-stop shop for record sealing. It also instructs ACIC to establish uniform petitions for felonies, misdemeanors, specifically for controlled substances, and then, of course, offenses that are null pros, dismissed, or you're found not guilty, you're acquitted. Misdemeanors under the CCRSA, it was changed dramatically in 2019. What the whole act was. It used to be there was a 60-day waiting period after you completed your sentence to seal your record, and that's no longer the case. It used to be there was a filing fee. That's also no longer the case. But what you have to do to be eligible to seal your offense is complete all terms of your sentence. That includes paying any restitution or court costs, and then also reinstating your driver's license if that was suspended as part of your sentence, or administratively, like for a DWI. That one gets forgotten a lot. There's no limit on the number of misdemeanors that you can seal. You can do as many as you want. However, there is a waiting period for several types of misdemeanors. They're kind of the ones you'd imagine: negligent homicide, sexual assault, DWI. The common waiting period for all these, with the exception of DWI, is 5 years. The waiting period on DWI has changed, and I'll discuss that in the new section. But other than those offenses found in that statute, you can seal as soon as the sentence is complete.
We've got a question going back to Act 346.
Sure.
So if you go to the Department of Community Corrections or Department of Corrections facility, you cannot have been sentenced under Act 346. Is that correct?
Correct. 346 is probation. That's my understanding. I'm happy to double check it.
Okay, and that's it.
Felonies under the CCRSA, those are going to be the most impactful for sealing your client's record. I guess I'll take that back. I'll back up again. Act 346, I have seen cases where someone's been sentenced to a term of imprisonment in RPF as a condition of their probated sentence, in which case that would qualify. However, if it was just straight to ADC, straight to prison, and that was your sentence, that would not. So I'm correcting myself, yes, you can serve some time. However, usually it would be pursuant to a term of on your probation terms.
So there's kind of a follow-up comment or question on that. It says you could do it if you were on probation plus, right? Like probation plus 120 days of ACC.
Correct. Yeah, and that's what I neglected to mention or didn't think of. So I appreciate the catch. Yeah, you can be sentenced as long as you're sentenced to probation. That counts, and one of the terms of your probation can be a term, probation plus.
Okay, we have one more comment. No, they're still coming in. Okay, so we have a comment. Not a question, but I have a case right now, and the only place I can find the person was sentenced to 346 was on the probation conditions. I don't usually request that document from the client, but the clerk sent me the sentencing order and probation conditions in the same scan, and I'm glad she did.
Yeah, that's definitely a great place to look as well. When I would almost pull the whole case file when you're collecting documents to determine eligibility, exactly for that reason. Whomever represented the client on the front end may not have filed the order for Act 346, or may not have checked it on the sentencing order. So it's good to check all the probation conditions as well, because that exact thing happens. And I think you have a good argument, even though it's not checked on the sentencing order, that it was pursuant to Act 346 because it's marked on these sentencing conditions, which are also signed by the judge and the client and acknowledged. That's a good place to look as well.
Okay, and so we have one more question. I'm going to jinx myself by saying that. So if you already utilize your one Act 346, then subsequently get another felony or otherwise, can you use one of the other acts to seal your second record?
Absolutely. And it generally goes that way, and it's important to actually transition as well. Thanks for the segue into this. kind of on the side there, one of the restrictions is that you have no more than one prior felony conviction, which is, I guess, a fun way for the legislature to say you can use it twice. But it's specific and says conviction. Remember, Act 346 is not a conviction. So you can use your Act 346 and then still seal 2 felonies after that using CCRSA. So yes, absolutely, you can still seal other things after you use your 346. However, one caveat there is it's not necessarily felony convictions or felony offenses, right? The criminal episode rule applies. So if I am charged with 10 counts of forgery, we can seal that and that counts as 1 because it's all in one case, as long as it's in one case or one case number. So it's not, you can pick 2 and 8 remain, you can seal 2 felony cases using the criminal episode rule. As far as what qualifies as a felony that is eligible to be sealed, C's and D's are the felony levels that can almost universally be sealed, with the exception of violent felonies. Those you have to, you can seal those immediately, C's and D's, and unclassified felonies immediately, with the exception of violent felonies, which have a 5-year waiting period. And then additionally, you have to, of course, complete the terms of your sentence. So if it takes you 5 years to pay off your fines, fees, and costs, you've got to wait 5 more years if it's a violent felony, because it's 5 years from the completion of your sentence. A's and B's are generally not allowed to be sealed pursuant to the CCRSA. The exception is A and B drug felonies. There's a specific carve out that allows for those to be sealed pursuant to this. Just, I think, a push to reduce some of the impact that drug policies have had. Another kind of continuing that, there's a statute for eligible felony offenses and then ineligible felony offenses. The class Y felonies, class A or B, again, accepted for drug felonies, manslaughter, unclassified felonies if their sentence is above 10 years, felony sex offenses, felonies involving violence, which are specifically defined in another statute, the habitual offender statute. And those are all the things you would generally think of the legislature not wanting people to seal: murder, kidnapping, aggravated robbery, rape, etc. Sometimes, and everyone's aware, you get arrested or charged, but the case may ultimately be null prossed or dismissed, or you're found not guilty. And you can seal those as well, because just like a conviction on a background check could harm your ability to get a job or to get an apartment or rent a place, so can just the fact you were arrested, or charged. So the CCRSA has specific forms to use when you're attempting to seal an acquittal, a null pros, or an order of dismissal, or if you were just arrested but not charged. There's a waiting period for if you're arrested but not charged. And then, of course, there's a waiting period of 1 year if the charge was null pros, just because a null pros is technically a dismissal without prejudice. They can refile it again for 1 year. Hearings. I mentioned earlier that the prosecutor has the right to object, and they have 30 days. They can object to the sealing, and we'll talk about what their burden of proof is. But the timeline's important. They have 30 days to object, and if they don't, the judge can just act on it, can approve or deny. But if the prosecutor does object, the judge can't just grant it. They have to have a hearing. They may have a hearing, but cannot grant it unless that hearing is held. So and that changed a little bit this year. It clarified the timeline, and it's a little bit odd that you may set it for a hearing. They don't have to, but they cannot grant it unless that hearing is held. So this, as Mallory mentioned earlier, requesting a hearing can sometimes get things moving. At the hearings, the burden of proof changes depending on what's going on. So if the sealing action is pursuant to Act 346, the First Offenders Act, the judge doesn't have any discretion. If the terms and conditions were satisfied, the charges will be dismissed and the order will be entered. And then the court clerks have some work to do regarding entering that order and sequestering the records. But it's a shall, there's no discretion. If a misdemeanor, if it's a misdemeanor conviction, the court shall seal unless presented with clear and convincing evidence that it should not be sealed. Felonies are kind of flipped. The court may grant if it finds by clear and convincing evidence that it would further the interests of justice. So that burdens on the defense at that point or the petitioner. And then there are a lot of factors that are listed for furthering the interests of justice, and those are listed. And of course, at the end, it's and all other relevant factors. So those are found at that site. As far as arrests, null pros, dismissals, and acquittals, it shall grant unless the state proves by a preponderance the public would be at risk or it would not further the interests of justice. Now what's next? If your petition is granted or denied, an order will be entered. The uniform order that you would have filed with the petition is found on ACIC's website. If it's granted, the order is sealed. They pull it from ACI or pull it from Court Connect. If it's in district court and they're not on Court Connect, the court clerks have an obligation to sequester those files somewhere else. It can be the same building, doesn't have to be somewhere, but it's in a different set of files than the normal filing system for those offenses. The court clerks also have a statutory duty to notify ACIC and send a report that assign the order to the arresting agency as well. If denied, you have appellate rights. If you are appealing from district court to circuit court, it's a de novo appeal. You start all over just like one would expect. But if you appeal from circuit court to a court of appeals, it's an abuse of discretion standard. And there's some timelines for how long you can appeal or file again. You can just wait a year and file again to seal your record. Maybe things have changed. You're able to provide more character witnesses or maybe prove up to the judge that it does further the interests of justice. And that statute is very explicit and spells all that out what your timelines are.
We have a few more questions if you'd like them.
Yeah, hit me.
For the charges not filed provision, if a
Mhm.
person has been arrested for a felony, but the prosecutor has declined to file charges, can the petition be filed immediately after the prosecutor's decision is made?
The statute says a year after the arrest. I wouldn't be afraid of trying to seal it sooner if the prosecutor is going to provide a letter or tell the judge, hey, I don't object. I'm definitely not going to go ahead. I think the statute says they've got to wait a year or you have to wait a year, but you got a prosecutor who's on board, I'd try it.
Okay. And is a hearing required for the Act 346 petitions?
No, and I've never heard of one. It's just signed, sent to the judge and the judge signs it. I'm sure a mechanism exists to hear just about anything if there's an issue. Maybe the prosecutor objects and says that the probation terms weren't completed 100% of the way and they want to fight about it. I'm sure there's a mechanism to have that hearing. I've never heard of one.
Okay, and that's it for now.
Perfect. So that was the CCRSA, which again is going to be the bulk of what everyone uses. The Community Punishment Act is still around. I think it'll be phased out largely because of some of the new legislation that was passed. But I'm still going to touch on it. It was primarily around due to Bolin v. States, which is a case that specified the CCRSA only applied to prospective felonies that occurred after January 1st, 2014. Felonies prior to that date were not allowed to be used under CCRSA. So Community Punishment Act was still around. This is an older act. It uses target offenses, if anyone's familiar with using target offenses for RPF. However, the sentencing order does not necessarily have to refer to this act, as long as it's the charge of the appropriate type and the substantive requirements are otherwise met, you can go forward and use it. It has some similar requirements to the CCRSA. It can't be used for certain types of felonies. It can't be used at all if you've been convicted of certain felonies. And it can also be used only on 2 felonies. Worth mentioning briefly are specialty courts. They are largely drug court There are a few veterans courts, especially up here near the VA. I assume there's some down in Pulaski as well, around the bases there. But they are almost interchangeable as how it affects people's records. Those familiar with drug court, veterans court are familiar with pre and post adjudication. So if it's pre-adjudication, you're just sent over to drug court, your case is transferred. And then once you successfully complete it, an order of dismissal is entered, just similar to 346. But it could also be ordered post adjudication, where it is a conviction. And then as a condition of your sentence is to complete drug court. You probably won't see many of these. We don't see many of these. Usually drug court staff, which is a phenomenal program, they do a lot of aftercare, or they assist, their clients who have graduated the program in entering those orders and then doing anything else, sealing other offenses that weren't in drug court. So it's unlikely you'll see many of these, but it bears mentioning. Another thing that bears mentioning is the sex offender registry. Sealing your record does not get you off the registry. It is not the correct process. There's a separate process for that. That is all located at 1212-919. I won't jump into that too much, but generally just have to wait 15 years. And there's a burden you have to prove by preponderance of the evidence as well. Earlier I mentioned Act 346 is one of the two ways to get you restore your gun rights. The other way is a pardon, and there's three types of pardons: a full pardon, a pardon with no gun rights restored, and then just gun rights restored. It's an uphill battle. It's very unlikely it's going to happen. It has to go through not only the parole board, but the governor as well, and there's likely political ramifications with any governor granting pardon. So I think it's unlikely, but it's definitely a process that's out there. There's that ACIC page does have pardon information, and there's a link in our slideshow as well. If someone's going after just gun rights being restored, the sheriff actually has to sign off on it too.
We had a question come in.
Sure.
What should you do if you know you have a misdemeanor, or you have misdemeanor convictions or convictions held under advisement and don't show up on ACIC report?
I think it's still worth sealing anyway. I think it's rare that background checks are going to be more thorough than just requesting ACIC or their own internal database. However, I think it would not be unheard of for like a local landlord to call around to the courts and ask if there's been any convictions for individuals. In which case, if there is something, the public record, the court clerk they may have a policy of not answering it unless you're the individual, but I don't think there's anything stopping them from it unless it's sealed. Then they have to answer that there's no record of a conviction. So even if ACIC didn't get the memo, I think it's worthwhile, one, because if they call the court clerk and the court answers, it's there. And that's more for district courts. Two, it'll pull it off Court Connect. So if it's on Court Connect, but somehow ACIC didn't get it, the court clerk will pull it from Court Connect. And then three, if you do that private background check and the private company has it, having the order can make, you can correct the record of the background check with that order.
Thank you.
So 2021 updates, that's the 50% of you that said, oh, I know all that already, Josh, hurry up, get me to the new stuff. Tune back in. These updates are effective July 28th. We actually spoke with Brad Zord, ACIC. He says all the forms and changes are ready to go. They're not going to go live on the website until 28th, so we've got another week or so still. There are three that are impactful, but I think the biggest one is Act 341. The changes it made are allowing convictions that resulted in a Department of Corrections sentence to be sealed. Previously, any felony in which you served time in the DOC could not be sealed. And that created some confusion because for a while, RPF or CCC was its own entity, not under the Department of Correction or Division of Corrections. But then they consolidated. Now they're both under the same umbrella. So does that mean now you can't seal anything that went to RPF? There's just a lot of confusion there. Anyone familiar with the Arkansas laws and legislature is not surprised. But explicitly now, anyone sentenced to any any sentence in the Division of Correction, as long as the offense is eligible to be sealed, can be sealed. The second biggest change is clearing up that Boland distinction, pre and post 2014. Again, the Boland case, the court said, well, the legislature intended for misdemeanors committed at any time to be sealed, but they didn't intend that for felonies. So let's clean that up. Any felony committed pre or post 2014 can now be sealed. The actual language they added is regardless of when the felony occurred. And so that helps a lot. Previously, we were stuck using the Community Punishment Act for anything that occurred prior to 2014, any felonies that occurred. Act 341 also clarified the timeline for objecting. The prosecutor has 30 days to object. If not, the court can act, grant or deny after the 30-day period. But as I mentioned, if there is an objection, the court may or may not grant the hearing, but they can't grant the petition without that hearing. And it also just cleaned up some language, just like normal bills would. Clear grammar, just made it more clear. The next most impactful change is Act 1037. It instructed ACIC to create a uniform petition specifically for DWIs and BWIs, boating while intoxicated. Previously, and anyone who deals with criminal defense knows that DWIs can be felony or misdemeanor. So you change your petition depending on which type it was. So now we've got one petition specifically for those offenses. And also of note is that another act, Act 274, changed the look back periods for DWIs. A misdemeanor, again, well, 5 to 10 years is a look back for most, and it changed from 5 to 10 years for most DWIs, but then it also changed 10 to 20 on the DWI offenses that look back that far. So look back periods were 5 and 10, now they're 10 and 20. And that also changes the time in which you're eligible to seal. Act 1037 addresses that in depth. Act 690 is kind of the throwaway. There's the petition to seal a drug felony, which isn't the +1 to the other felonies you seal. So it's kind of odd that it's its own thing. But it didn't specify felony previously, so they added felony to the language with 690. Other changes that we expect, one, again, of course, there's going to be a new DWI statute, or petition, excuse me. And then it seems to be that there's going to be a new Veterans Treatment Court petition. I don't know why they can't use one specialty court, but I'll be able to look out for which specialty court, if you get a client, which they attended. The updates to the existing petitions, they are going to be removing the DOC language from the CCRSAs, because again, previously, sentence to the Department of Corrections or Division of Corrections, excuse me, you can't seal it. They're going to clarify that separate petition for drug felonies. This may be a little bit wishful thinking on my part, but I'm hoping the uniform petitions become a little more uniform. As of now, they look different, even from felony to misdemeanor, even under the CCRSA, the fields, different fonts sometimes. So it's just a little inconsistent, which doesn't affect it substantively, but it's just Josh's wishful thinking. And additionally, hopefully they're going to be removing the filing fee language, which again was changed in 2019. Any questions?
Yes. Yeah, we have one. Just for clarification, is the wait time to seal a DWI still 5 years?
So it changed with the look back period. That the statute or the Act 1037 reads to everyone I've talked to and to me that the new time to seal a DWI is 5 years after the look back period. So I think there's some confusion about it, and I'm planning on seeing what the petition and order say. I think there's going to be a little bit of clarification from ACIC and how they interpret that law. But pull 1037, take a look at it. It's, in my opinion, a little confusing, but The look back periods, I think, are going to be what the waiting period matches. You match the look back period and it just bumps the time backwards.
And that's it for now.
I think we've got another housekeeping poll for CLE credit. Make sure everyone's still awake. We have another one.
Yes, just a second. Okay, so I'm launching a poll now. What is the last day to send your CLE form to cle@arkansasjustice.org to receive CLE credit? And just a reminder, we do need you to send it to that blanket email address, not directly to any Arkansas Access to Justice staff. We have a few people still answering the poll, but I don't need to read the results because it's all the same answer. We need them by Wednesday, July 28th. And I will be following up on that with you guys. So thank you.
You'll hear the disembodied voice of Mallory. I'll try to scoot the camera over a little bit so we're both here.
Yeah, really talk to me here. So we're gonna squeeze in some practice tips at the end. I know Josh mentioned this a couple of times before, but don't rely solely on Court Connect or ACIC. Go ahead and pull a sentencing order, the ACIC report and Court Connect. Compare those and make sure you're sealing what's actually the conviction.
Local court clerks, I think bear mentioning, just because again, most district courts do things a little bit differently. Some examples of that, there's a county over in eastern Arkansas that the judge won't even look at the petition, the clerk won't even accept the petition unless the prosecutor's already signed off on it, which is not the statutory requirement at all, but that's how they do it, and they're not changing. So just be familiar with your local clerks. I think there is a court locally who the judge accepts letters from the defendants rather than the petition, a mea culpa letter saying, how they've changed and such.
And then go ahead and pull an ACIC report for your client after the case has been closed, sealed, and pulled from Court Connect. Just like we talked about earlier, that 25% or whatever the commenter said of ACICs that are inaccurate, double check it after you've got it sealed. So now's the best time to go ahead and correct it if it didn't come down properly.
The thing I think is very important is taking the order and updating criminal database. Follow that link there when you get the PowerPoints. There's a nonprofit that takes the orders you send them and sends it to hundreds of private databases. So these background check companies that are not necessarily going to be updating their records when something goes off Court Connect. So it informs those hundreds of companies, hey, this person's been sealed. Here's the statute. Here's the order. This is deemed by law not to have occurred. So that can make a big difference for your client trying to get their record sealed later.
And then again, ask for a hearing. We've had multiple experiences where we've had a petition languishing for a year or more, and we just have to start requesting hearings to get that moving along. Prosecutors will tell you they're going to object. They write on your petition, I object, but there's never a reason articulated. So if you force it to a hearing or at least getting a hearing set, we found that those magically signed orders somehow would just start appearing at that point.
Lastly, Mallory touched on this earlier. The language of the record sealing statute is really important. It's deemed by law not to have occurred. So if your client gets rejected for housing or gets denied a job and you're trying to correct that, sometimes providing that employer with, hey, here's the order sealing it. Here is the statute that says it's deemed by law not to have occurred. He wasn't lying to you. He answered the question truthfully as allowed by law, and hopefully that clears up and your client can get the job.
And I talked about restoring your right to vote earlier. This is my little platform I plug for all my clients now, because last presidential election cycle, we had a lot of folks trying to vote and thought they could vote, but finding out at the polls that a clerk or a poll worker has a list of felons and they're getting marked off based on that. So completing the sentence first, pay all the court fines, court costs, release from probation, provide the proof of that, the satisfaction of judgment to the clerk with your voting application, and then actually encourage your client to follow up and make sure they are registered to vote. They can check on that registration prior to showing up at the polls. I tried to fly through those last there at the end. We do have a couple more minutes for questions. Christy, I think there's one more popping up.
Yeah, we have one that says, who do you contact to make sure is given to background check services?
So that the link, do you remember the name of the nonprofit?
Continuing just, I just lost the name of it, but I
Yes.
linked the form in there.
I wonder if I can follow it.
But I think they require a certified copy of the order. So that's a little bit of a hassle to get sometimes, but it takes care of quite a few background check companies.
Continuingjustice.org is their website, and they're called the Foundation for Continuing Justice. It's a pretty simple form, and then you just send in the order. And the link is here if you didn't catch that URL. I think our PowerPoints will sent out, or will be. If you don't get it, email me.
So we utilize volunteer attorneys quite often. So if anyone is interested in taking on cases, by all means, please let Christy know in your forums or reach out to us. We also handle numerous record sealing clinics throughout the year. We were hoping to do our first in-person clinic in a while this fall. We'll see how that goes. But if you have any interest in assisting us with that, by all means, please holler at us. Both of our contact information are there. If you are helping to clients to seal records and you have any questions or want to know if we have any insight about the area of Arkansas you're practicing in, let us know. I have a list of horror stories to share just in case we were too under on our time. So I'd be happy to swap stories with you and give you some ideas as well. And then last little plug there, our helpline number and hours are on there. Look at things.
I'm back up.
I think it's still showing.
Okay.
So I was guilty of this too. Whenever you hear of a client that legal aid can maybe help, you just tell them to call legal aid. But actually we have an intake process and a helpline with staffed hours. So please give these potential clients our helpline number. And if we can assist them, we will. And I think that, you have any closing remarks?
I don't. This is just an important thing. It's important to me. And, we obviously do a lot of them. Look forward to seeing you guys at the volunteer. We can teach you how to do it too. It's not just you've got to know how to do it to come on in. But if you ever have any questions or run into any issues, I'm not the expert, but feel free to email us. We can help out how we can.
Okay, I'm just going to read a few comments we had come in.
Okay.
One just thank you is from Jesse Birchfield. Thank you for this great CLE. I'm teaching SLR criminal law this fall, and we'll do a sealing exercise and give you a shout out.
Thanks, Jesse.
Yeah, thanks, Dean Birchfield. And earlier we had another comment that I was going to skip it if we didn't have enough time, but I think we had someone make a comment about someone lying, and so we had another comment kind of clarifying. You don't lie if your charge was sealed. They need to request a copy of the report upon which the employer relied. If the report is incorrect, the employer should be given an opportunity to hire or rehire. The denial of the employee was based on this. They may have a cause of action against the screening company if the report had inaccurate information. So
Yes,
I don't know.
there's some FCRA cases that can come out of those as well.
All right. I'm trying to, we got one, oh, nope, it's 1 o'clock now. Okay. So just a reminder, I will send out CLE forms from the CLE at arkansasjustice.org email address this afternoon to those who were here for at least 60 minutes and answered at least one poll question. And we will need those forms back by Wednesday of this coming week. And so thank you guys so much. That was a great presentation. We had a really active group today, and that always makes it more interesting. And so we really appreciate you guys for being here.
Thank you guys.
Thanks, Christy.